and we are only touching on Section 18 of the bill, Funds of Service, which states, the service shall establish and maintain a fund which shall consist of and which shall be credited an amount not less than 10% and not more than 15% of all revenue collected by the service in the preceding month of on a monthly basis. This is too outrageous. If we are to make comment on this, we will be recommending, because the scope will be very wide, but eventually the bill scaled through, you will be covering the entire state, and so we will be recommending 0.5% and not more than 1%. We are aware that members of the AKROS are civil servants that are drawn from other agencies and MDAs, and so the salary still runs. We do not know why you will need such huge amount of money if you are a civil servant. That is one. Same thing applies to Section 18 in the Akha Ibom State Taxes and Levies Bill 2025. If you check Section 18, you will also see sharing of property tax. The revenue realized from the imposition of property tax shall, after deduction of operational costs of 10% incurred by the collecting authority, be shared as follows. A, the portion belonging to the state, being 40%, shall be deducted first, and then B, the portion belonging to the local government councils, being 60%, shall be converted to 100% and shared on the basis of equality 40% and derivation 60%. We also have an objection to that if we are to comment on the bill. We will think that the percentage, the 10% that will be deducted by the collecting authority is very outrageous and very strenuous, because the collecting agency or authority, staffers of that agency are members of the civil service drawn from the state. And so it will be too huge if we are to even talk about the bill. However, today I feel very elated and happy to say that this is the first time I will be attending a public hearing on executive bill, and the executive council members are coming to give me a foundation to stand on to criticize the bill. Having said that, our job is made easier by the Commissioner for Finance, that of Transport, and other council members. Yes, Mr. Speaker said that the public hearing is for us to bring knife and pepper. I am bringing both of them to add for this public hearing. We have a written document which I'm going to present, and after which I believe the Assembly will take their position. An overview of the Akha Ibom State Taxes and Levies Bill 2025. We are going to dwell more on this. The bill has 46 sections and one schedule. The bill is divided into 4 functional parts. Part 1 makes provision for the harmonized taxes and levies and the objective of the bill. Part 2 makes provision for the property tax. Part 3 makes provision for taxes on lottery, betting, casino, and other gaming activities. And Part 4 makes provision for miscellaneous provisions. The bill seeks to harmonize various taxes and levies in Akha Ibom State. The Crown has critically analyzed the bill. Our input, therefore. In Section 16 and 19 of the bill, the Crown notes that the bill seeks to make tenancy life become a life of hardship and misery, as any tax or taxes imposed on real property owners and landlords will be transferred to the tenant in Akha Ibom State. Item number 2. In Section 21, sub 2 of the bill, the center notes that the bill seeks to promote absentee landlords. by transferring the liability of the landlords to the occupiers of the property without even masking to be anti-people. The NSC chairman talked about this, where you don't see the landlord, you give the demand notice to the tenant or whoever is there to come and pay for the levies. Item number 3, the Crown observes that the bill does not distinguish between houses in the urban cities and houses in the rural communities. Even houses occupied by the poorest of the poor in the society, including occupants of mud houses, will be taxed in line with Section 16 and 19 of the bill. This completely negates the campaign mantra of the Arise agenda, which portrays the executive governor of Akwa Ibom State, His Excellency Pastor Umoino, to be a friend of the poor and lover of the poorest of the poor in our society. Number 4, the Crown observes that the items so listed in the schedule to the bill have strangulating characteristics that will shut down private sector economy in Akwa Ibom State. The center notes that the bill does not allow citizens the ambience to maneuver. The bill is very stringent and only interested in collecting revenue for the government without any ambience for reliefs in favor of citizens of Akwa Ibom State. 5, the Crown notes that the Akwa Ibom State is a civil service state which with little or no functional state-owned industries and factories. The private sector in Akwa Ibom State hardly survives due to epileptic electricity power supply, lack of water supply from Akwa Ibom Water Company, and lack of supporting public infrastructural amenities to create enabling environment for private businesses to thrive in Akwa Ibom State. Few surviving private businesses in Akwa Ibom State have resorted to alternative source of power, such as generating sets, powered at higher cost of fuel and diesel. You now bring tax to them to further cripple their businesses. Number 6, the Crown observes that certain terms invented by the bills are dangerously calculated to emasculate Akwa Ibom citizens and create dubious ambiguity. For instance, the word enforcement as used in the context of Section 28 sub 2 of the bill is capable of many dubious interpretations, including meaning seizure of people's property. To further doubt the motive of the word enforcement used in Section 28 sub 2 of the bill, there is no definition of the word enforcement in Section 30, which is where all the words are interpreted in the bill. What then do we mean by enforcement? Section 7, item 7, the bill, the center notes, given the word enforcement, given that the word enforcement is deployed under Section 28 of the bill that deals with default in payment, it could only have been invented to cause destruction of lives of the poor in Akwa Ibom State. The Crown notes that Section 28 sub 1 of the bill stipulating default in payment to the extent that, quote, where a person who has received a property tax demand notice fails to pay the amount within the period specified in the notice, the charge payable will be increased by the following percentage: between 45 and 75 days, 25%; between 76 and 105 days, 50%; and between 106 and 135 days, 100%. Unquote. In effect, if one's assessment is 100% and one default in payment, when it is 135 days, one will now pay 200,000 naira. And if payment is not made after 135 days, the property on which the property tax payment shall be liable to enforcement under the provision of this part of the bill by the Akwa Ibom State Internal Revenue Services or its appointed agent until all outstanding taxes, penalties, and costs are paid. What then is draconian than such kind of a piece of legislation? Item number 8, the Crown observes that the bill is in violation of section 43 of our Nigerian Constitution, which guarantees every citizen of Nigeria the right to acquire and own properties anywhere in Nigeria, as well as Article 14 of the African Charter on Human and People's Rights, 1981, and Article 17 of Universal Declaration on Human Rights, 1948, which Nigeria is a signatory to. The Crown notes that in other claims, citizens' right to ownership of property is recognized and protected under several human rights instruments. Why are we different in Akwa Ibom? In our conclusion, the Crown states that there are no better definitions to the words draconian, anti-people, oppressive, monstrous, and obnoxious than the provisions of this bill, which seeks to punish poverty and further impoverish the already deprived citizens of Akwa Ibom State. The Crown rejects this bill in its entirety and calls on members of the Akwa Ibom State House of Assembly that pride itself as the People's Assembly to rise in support of the citizens, include their names in the annals of history by standing down for the consideration of this bill. The Crown recalls that a similar bill was presented to the Akwa Ibom State House of Assembly in 2016, and it was outrightly rejected because we consider it as witchcraft bill that will further kill businesses in the state. We thank the Assembly for bringing us here to make input, and we hope that at the end of the day, our views will be considered because we believe that Akwa Ibom State deserves the best. Thank you so much.